Hello, Law 1204. We are here today with our final aspects of content for this semester via video lecture. So there's a few different video lectures coming to you for this content. These slides were posted last Friday on April 2nd, 3rd. So you have had access to the slides already, and we had a brief class discussion about this stuff. There are readings posted for you on DC Connect as well, so please pay attention to all of those resources. We're talking specifically now about different kinds of liabilities, special liabilities. So this first portion of the video lecture will focus on strict liability. Then there'll be a second portion on vicarious liability. The slides also cover crown liability. Crown liability is not an area that's covered on your final test. These two first areas, strict liability and vicarious liability, are. And then also pay attention to a third part of slides for today for damages, a general discussion on damages in this area of law. So strict liability, what is this? Strict liability is a unique area of tort law that basically says when there's harm caused to a plaintiff by non-negligent conduct, and even where the defendant has taken reasonable care to prevent harm. So essentially this creates liability without fault. We've talked about intentional torts, so there's an intended act against another person. We've talked about unintentional torts, like negligence, so there's just negligence on behalf of a party. Strict liability takes that one step further and says there was not necessarily negligence. In fact, in the main case that we're going to look at, it shows that negligence could not be found by the court, but the court still felt that this defendant still owed some duty to the plaintiff, and so therefore there was going to be liability found. Okay, so it sort of kind of contradicts the social idea or the social context that we live in that you're found liable to someone for the harm that you've created if you're at fault. This is saying even if you're not at fault, you still can be found liable for harms created or caused to another individual. Okay. So because this is sort of outside of the construct of what our society typically likes, so harm, liability, or affixing liability to someone who hasn't acted negligently or intentionally, we have tried to limit the use of this tort to areas where there's something inherently dangerous that escapes the property and then causes harm to a third person or to a third party, okay? The greater the danger that exists, the greater the duty of care that is owed to the individual or to the outside people, neighbors who might come in contact with us, okay? So the case that this stems from is Rylance versus Fletcher. It's called Rylance versus Fletcher because in its appeal decision, where it ended up, it would have been Rylance who appealed the decision. So their name appears first. The reason I'm pointing this out to you, I probably should backtrack. Fletcher is actually the plaintiff in this case, and typically you see the plaintiff's name first in a style of cause, but when it's on appeal, the party who's on appeal, their name will reverse and flip, and so that's why we're seeing this as Rylance versus Fletcher, as opposed to Fletcher versus Rylance, but it is Fletcher who is the plaintiff here, okay? So what's happening here is Rylance has permission to build a water reservoir for another defendant's textile mill on this land, okay? It happened to be the Earl of Wilton's land, whose land it is, we're not too concerned about for the purposes of understanding strict liability, okay? So Rylance builds this water reservoir. Fletcher, who is the plaintiff, he has a coal mine. So water reservoir is above ground, coal mine is below ground, okay? Right below the reservoir, Fletcher builds his coal mine. Water from the reservoir breaks through the shafts into the mine and floods the mine. Okay, so the Fletcher sues Rylance for negligence. The court considers the way in which Rylance constructed the reservoir and that they used architects and engineers and found that there was no negligence at all. This act just happened. So this is where strict liability is first found to apply in a case. The courts say there's no liability on the basis of negligence here. There was no proof of a negligent act. However, it's not really fair that Fletcher now has to bear all of this financial burden and the harm that was caused to his coal mine as a result of something that happened from Ryland's reservoir above. And so therefore liability is created. Liability is extended here to Rylance, okay? The trial level court actually found that the defendant was liable because the activity was hazardous in nature and it was solely for his profit. So those are two big talking points that come out of the trial level decision. Okay, hazardous in nature and for his purpose, and therefore for his profit, I should say, sorry, and therefore he must be responsible to bear the burden of the cost that the harm others have suffered harm from. The House of Lords upholds the decision that he's liable, Rylands, but steps away a little bit from this concept of hazardous activity towards unnatural use of the land, okay, that therefore causes harm to another. In other words, water itself isn't dangerous, right? But it's the unnatural use of that land, hosting large amounts of water in one place, that has created this unnatural use or this hazardous impact, right, that has escaped and now caused harm to another party. A quote from the case itself: "The person who for his own purpose brings on his land anything likely to do mischief, if it escapes," mischief meaning, create a problem, "must keep it at his peril, and is prima facie answerable for all the damage which is the natural consequence of its escape." So you bring something onto your land that's not supposed to be there, and possibly it could create some kind of havoc. If it is released from your land, if it escapes, then you're going to be responsible for whatever that harm is to other people. Okay? That's essentially the strict liability in a nutshell. So again, unnatural use doesn't necessarily mean dangerous or hazardous on its own. Water on its own is not dangerous or hazardous, but the use of it is what makes it dangerous or hazardous. Okay? Some kind of unnatural use. An example in the slides is given to you as salt. Salt is not a bad thing. By salt, I don't necessarily mean food, the stuff that we ingest and season our food with, because we know that can also be bad if you have too much of it. But salt in the winter is a good thing on our roads. We want salt on our roads and on our walkways to make it less slippery for our cars and our feet, right? But if salt like that is used improperly, it can cause damage to somebody's property. If the salter is going down the street shooting ridiculous amounts of salt out, perhaps more than it should have been shooting out, and it lands all on the property and destroys somebody's grass, that could be an example of how something that is very natural is used unnaturally, which then causes harm to somebody, right? So strict liability, its use has been limited to cases where the activity is both hazardous and unnatural. It is unnatural if the effect of the thing, whatever it might be, has caused danger, okay? The thing itself doesn't have to be dangerous. And then we have this aspect as well about bringing it onto the land. So aside from it being hazardous and unnatural, the defendant must have also brought whatever it is onto the land, and it must have escaped from the land to have caused harm. So in the example of Rylands and Fletcher, Rylands brings water, excess amounts, onto the land in this water reservoir, right? And then it escapes. If you have a tiger in your backyard, you've brought a tiger, something that's unnatural, to that landscape in the community onto your property. It doesn't matter how many signs you have and barbed wire fencing that says, beware of tiger. If that tiger escapes and causes harm to somebody, you're going to be found liable on the basis of this strict liability offense, okay? Or tort, I should say. Strict liability offense is in criminal law as well, but we're talking about tort law here. This doctrine is meant to catch innocent but harmful acts. And I just want to reiterate that again, because again, we're not looking at intentional torts or even areas of negligence, okay? Completely innocent act, but it has somehow caused harm to somebody else. Defenses to strict liability then, so if you are the plaintiff and you are claiming damages against a defendant on the basis of a strict liability act, one defense that the defendant could raise is that, hold on a second, the plaintiff consented to this. Fletcher could have said, Rylands could have said, hold on a second, from the start, Fletcher agreed to me having water reservoir up here. He said it would be useful to him for A, B, C, and D, right? If the defendant can prove that the plaintiff had consented to whatever that act was, they can't therefore turn around and sue that individual. Acts of the plaintiff, where they have received damages as a result of their own conduct. What if you know that there is a tiger housed behind a fence, and you start waving a nice stake in front of the fence to try to encourage that tiger to jump out and grab that stake, or a Rottweiler if we're going to not go as extreme as a tiger. If you are inducing some kind of escape on your own, well then it's not fair that you can claim damages then, right? As a result of something you've done. If there's an act of God, so an earthquake, if it was an earthquake or a tornado or a hurricane that had caused that water reservoir to damage Fletcher's mines, he would have been out of luck to try to recover any damages, or to have liability found on behalf of Rylands, right? An act of God is an unforeseen, natural, extraordinary event. Act of third parties. So a defendant can say, hold on, it wasn't my fault. It's because somebody else came along and did whatever they did to cause this thing to escape, and therefore I shouldn't be held liable in strict liability. Maybe you should sue them in some kind of other action, right? And then, of course, if there's some kind of statutory authority that allows for anything to occur, and so therefore the defendant is acting as a result of a statute which requires him to do something, okay? So that would act as a defense for him as well. So then the next slide just shows you a civil action. This is a movie with John Travolta in, and I know I've mentioned John Travolta to you different times this class, and I don't have some strange infatuation with John Travolta. I don't know why he keeps coming up in this course, but this is an excellent movie, A Civil Action it's called, and it talks about strict liability in it. So it's based on a true story. So I would highly recommend you watch that in all of this free time that you have right now. Okay, I'm going to end this here on the discussion of strict liability, and we'll return shortly with a discussion on vicarious liability.